The Senzo Meyiwa murder trial has been full of unexpected turns, much of them involving defence advocate Malesela Teffo. Now, earlier this afternoon, he delivered another shock. He announced that he's withdrawing from the case and will no longer be representing accused numbers 1 to 4. 5 men, as you know, are standing trial for the murder of the football star Senzo Meyiwa, who was shot in Vosloorus in 2014. Teffo says he's being harassed, and that's why he's stepping back from the trial. Well, I'm joined now by legal expert Zola Majavu. Mr. Majavu, thank you so much for your time. How unusual is it for an advocate to step back from a trial at this point?
Good evening, Sally, and good evening to the viewers out there. I think perhaps let me foreshadow my response by saying the following. Advocates or all defense counsels, like all lawyers, are creations of their client's instructions. So it is not unusual for a defense counsel to withdraw at any stage of the proceedings. It may be as a result of the breakdown in the relationship of trust between him and the giver of his mandate, namely his client, or it could be for reasons that perhaps border on ethical considerations. Now, back to the case in point, it is extremely unusual for a defense counsel to withdraw in the manner that my colleague, Mr. Teffo, did. And what is most peculiar are the reasons advanced. It sounds to me like someone who either is not properly schooled in the rules of procedure or who simply cannot accept the fact that sometimes as lawyers, decisions do not necessarily go our client's way, and you have to man up and accept it. If you are aggrieved or your client is aggrieved, there are other processes that you may follow. So to accuse a court, a sitting judge, of being accused, number one, in some undefined conspiracy theory is in poor taste. And that is what makes it even most peculiar. Because if one listened to the reasons, when the judge gave us a ruling or a decision that we all knew was a long time coming, he then stands up and accuses the judge, accuses the presidency, and accuses all manner of institutions simply because he brought an application that was stillborn right from the start. You don't do that as a defense counsel. You accept that certain decisions may not go your way, and you have to remain within a modicum of respect, collegiality, and decorum to the court. What my colleague did is simply unacceptable, it is inexcusable, and not in our name as defense counsel. So it is certainly peculiar. There was absolutely no basis for the rant that we saw. What I do credit him for, though, is to bring to the fore the plight of his client. But unfortunately, he brought it before the wrong forum. That is not an issue that the presiding judge in this matter could have determined. At best for him, he should have taken the Department of Correctional Services to court, sharpening the issues that his client is rightly raising. But for him to then raise those issues, read a letter that did not disclose anything unusual, I think it was bound to fail from the beginning.
I mean, this is the thing, is that on one moment he's saying my client is being treated unfairly, he's in solitary confinement, and then the next he's saying, well, I'm not involved in this case anymore. As you say, a very peculiar turn of events. I'm wondering what your view is on what this means for the 4 men that he's been representing, because they have a right to a fair trial. Am I correct in my understanding is that there's still the instructing attorney who can then just appoint another advocate and this trial can go on? Or might we see this whole process have to start again?
Well, notionally, you are correct. The instructing attorney, as far as we know, is still very much on brief. It is open to him, if he is so instructed, to approach another counsel, or if he does have rights of appearance in the High Court, he can himself take over the matter because he has a working knowledge of the matter. If he is not inclined to go in that direction, or he is instructed to brief counsel, the reality is that a transcript would have to be produced. that new counsel will have to familiarize him or herself with the contents of that particular trial up until to date. Fortunately, there isn't much that really happened because a lot of the court time was spent, and I say this with respect, on side issues. We've only heard the evidence of one witness who is still under cross-examination. So it ought not to delay the matter terribly too much because the record itself, insofar as the actual gist of the case is concerned, is not much. But yes, the unintended consequence could be a further delay. In fact, if I were acting on behalf of accused number 5, and I say this without suggesting to Advocate Mshololo how she should conduct the case, I would probably consider bringing an application for a separation of trial so that whatever happens to accused number 1 to 4 should not unduly delay what ought to happen to accused number 5, because he too has a right, to a fair trial. He has a right to a speedy trial. He has a right to have this matter ventilated without undue delays. It would be unfortunate if the delay occasioned by what has happened to accused number 1 to 4 then affects his case, when in actual fact, today we're supposed to hear the issue about the jurisdiction point and also to afford Advocate Mshololo an opportunity to decide what she intends to make of her further cross-examination. We haven't even gone past the first witness, and we're told that there's a list of at least about 130 or so witnesses. Now, courts don't have that latitude of time to be squandered with us dealing with side issues that we as practitioners ought to know full well that there are processes that we have to follow if we wish to challenge certain things, as opposed to wasting the court's time with administrative issues. And now you've lost court time, and there are a whole host of other cases that are equally deserving of the court's attention. But yes, there's a possibility of a delay, but I think the judge and the cooperating counsel dealt with it properly by saying, let's have a holding date so that on the next occasion in August, it's merely a determination to see what has accused number 1 to 4 elected to do with reference to their right to legal representation, while they do not lose the other dates, the other 2 weeks set aside in September. So it may well be the case might be salvaged from a progress point of view.
Advocate Teffo made some startling comments during his time representing the 4. One of them that he would produce a witness that said Kelly Khumalo shot her boyfriend accidentally, and it caused a great deal of consternation. Also bringing this issue of the second docket, which is it's created a lot of confusion, and I would argue even more fertile breeding ground for conspiracy theories. But do you think, nonetheless, the issues that he's raised are important to consider and to engage with in this trial?
In fairness to Advocate Teffo, sometimes he is on to good points. There may well be something to be made about the existence of 2 dockets. But that on its own is of no moment if you choose to challenge it at the most inopportune moment in a criminal trial. The fact of the matter is the NPA, as the only entity on whom the authority to prosecute or to discontinue a prosecution rests, made a decision, rightly or wrongly, to say, we are going to go on this particular docket. And that is what they should have focused on, and show the weakness of the state's case for what it is by sharpening these contradictions. But it does not assist anyone to seek to challenge the NPA's decision before a judge who's a trial judge. And that is where, with respect, I think he missed the point. Secondly, you do not disclose your ace card to say, I have a witness who's going to say 1, 2, 3, and you put that version to a witness who has not implicated your client in any manner whatsoever. He had no business putting that version or proposition before Sergeant Musia, because Sergeant Musia, notional, it is a fact that he came there after the fact as a crime scene expert. Now, if you tell him what your witness is going to say when you're under no obligation to share with the state, who are you going to call? What are they going to call? You're not going to achieve anything, because that particular witness is simply going to say, I'm unable to comment, because you are putting to him a version about which he harbors no knowledge. Now, the other unintended consequence is that it may well be that that particular witness gets cold feet, or for whatever reason, they decide to come to court, and when they get into the witness box, they may recant on their story or on their version. And now you've already put a version definitively. I think it was inopportune. The other lapse of perhaps diplomacy, and I'm putting it at its most benevolent form to my colleague, was when he sought to make an issue about a confession. It may well be that his instructions are that a confession was not extracted properly in accordance with the laws. But you do not raise it before you know what the prosecutor's intentions are. It may well be that the prosecutor may still proceed without relying on that confession. But if the prosecutor indicates and he signals his intention to rely on a confession, at that point you then object, and then you go into what is called a trial within a trial, but only at that stage. So these are the issues that I think, even though Mr. Teffo may have been onto a good point, I think the manner in which he raised these issues was either inopportune or it was simply not strategically the correct moment to do so. But I would not discount that he may well be onto something good. But procedurally, I think he did miss the point. And I feel sorry for accused number 5 because their rights are also being adversely affected about things that they have nothing to do with them.
Thank you so much for your insight. It's brought me a lot of clarity, and let's hope we can go forward and see justice for Senzo Meyiwa, which really is what we're hoping for from this trial, and of course for his grieving family. Thank you very much for joining us this evening. That is legal expert Zola Majavu.